question for you. So say I detain a juvenile in the backseat of my car, handcuffed, for a felony, and I want to talk to him. Obviously, if I talk to him under those conditions, I got to Mirandize him. In California, we got to put him on the line with the lawyer. The lawyer's just going to tell him, don't talk. So the alternative is to take him out of the car, curbside detention, unhandcuff him, and then talk to him out of custody. I know 6 officers surrounding the juvenile would be considered custodial. I know 2 officers is good. So my question is, would 3 officers suffice? So say we're in like a triangle formation around the suspect and I want to talk to him outside of Miranda. Does that reach the arrest-like conditions, or is that good?
I think it's close. I mean, it's not unusual to see 2 officers having a conversation with a person. Once you start adding 3rd, 4th, and 5th in that immediate area around the person being questioned, there's a good argument that's an arrest-like environment. But that's not to say we can't mitigate it away by telling him he's not under arrest. Do you understand that you're not under arrest? With the reason we've got 2 other officers here is because of some flight risk concerns that we have about you, or some safety risk concerns. As with all 4th Amendment questions, these custodial questions are going to be fact-driven. It's going to be, what are the entire circumstances that we're dealing with here? It's not a definitive always 3 officers is always custody. It's an arrest-like measure that we need to make sure that we need to attempt to mitigate if that's what we're trying to do. Does the California rule apply even if when they're out of custody? We don't have to do the lawyer thing, right? Call the lawyer on the phone. Is that correct? In California?
No, they wouldn't. Only in custody.
Right. Okay.
So let me add a couple things here. So number one is for people who are not in California, just so you guys know, California, in my view, has the harshest juvenile rule in the country, and it basically says by statute that, and Andy, you correct me if I'm wrong, but if you have if a juvenile is in custody, just like you said, you have to call their lawyer has to give you approval to talk to them, and that's not going to happen, right, Andy?
Correct. So we don't even bother.
You don't even bother. So, okay. And by the way, there is a health and welfare code, whatever you guys call it, whatever the penal code is that you have to read a Miranda anyway. So and cops don't do that there, and that's fine. But a couple things. So this is referred to as taking the custody out of a detention. Okay. And a guy named Robert Phillips, who is one of my idols in California. Andy, have you heard of Robert Phillips? Legalupdates.com?
Yeah, I think I get the emails, but I'm not so sure.
Yeah, see a shame. So it's it's for those cops who are out there who have not signed up for legalupdates.com, please do. It's free. There's also a subscription service, but there's also great stuff for non-California cops because California is overall a 4th Amendment state. This is an exception to that because it's by statute. But look, this is called taking the detention of the custody of detention. The other thing that I want to say is that the behealer. Did you talk about behealer?
Yes.
Zach, tonight? Yeah. Right. I think you did. Right. So behealer is important here. Remind them that they're not under arrest. The final thing is that somebody did say, if he would not feel free to leave, then would be in custody. No. Custody and detention are 2 different things under Miranda. A person may be detained under Miranda. Right, Zach? You would agree with this, but not in custody for Miranda. A good example is a DUI, right? And there's a case on that, right? They're not free to leave. They're detained for Miranda for DUI, but they're not in custody. So therefore, Miranda would not apply.
Yeah, not free to leave. It's the test for a seizure under the 4th Amendment. All seizures are not Miranda custody. All Miranda custody are seizures.
Yeah, exactly. So Andy, to answer your question, I think the answer is yes. Do what you can. Can I also say one more thing? This is basically, I think it's worth it. I think it's worth to try to do this, Andy, even if the court disagrees with you and says, looking at it in my legal point of view, this juvenile was in custody for Miranda purposes. So, his testimony is not going to come in. There's 2 things about that I want you to know. Number one is you did not violate his 5th Amendment rights. This California statute is a statute. It does not mean that that you violate anybody's rights. And number two, quite frankly, it's kind of not really that effective because California is not allowed to make things more restrictive constitutionally. There is a Victims' Bill of Rights that was passed in like 1982 that says that California can't do that. There's already one case that says that it's coming in because California cannot make things more restrictive under the Constitution for Fourth and Fifth Amendments. However, I guess the point is I'm not teaching cops to violate their statute. That's what the people wanted by electing their elected officials. But try it. Hopefully the prosecutor argues it, but either way, the Constitution was not violated. Does that make sense, Andy?
Yeah, as far as the Miranda and not getting a lawyer, is that what you're talking about?
Yeah, just look, try to get him out of custody. Just like you said, I guess what I'm saying here is I'm not trying to be complicated, but try it and argue it, articulate it. And if the prosecutor doesn't agree, then we just go from there. It is what it is. You can always use that that testimony for impeachment anyway, right? Nobody's rights were violated, is what I'm trying to say. If you try it and the prosecutor doesn't agree, as long as you didn't coerce them, it's not unconstitutional. Period.
Right,
in California. Right. In California. But whatever anyway.
Copy that. I'll try it the next time. See what happens.
Yeah, just do be healer though. Make sure no matter what you do, be healer. You tell that person, the juvenile, they are not in custody, and then we go from there.
Copy that. Thank you.
You're welcome. Alex says, in California, do we still have to contact a lawyer for a juvenile if we make an arrest but don't read Miranda? Well, no. If you're not going to talk to them, Zach, you know how to get rid of. Hold on, I got it. Just go to Andy and say disable talking so that he doesn't have that mic issue. Alex says in California, no. The answer is that they're not in. If you're not going to look to talk to them, then you don't really need to do that lawyer thing. I was just saying I did read a penal code or whatever it was the other day that said that no matter what, California has a law that you have to read a Miranda as a matter of routine, but who cares? If you're not going to interview them, then I'm not reading it and nobody's going to say anything.